Hi, and welcome everyone to the English show. My name is Stephanie here at Beltran, Brito, accompanied by my partner, Alexis. How we doing?
What's going on, Stephanie? You look frozen. What's going on?
Oh no, am I frozen?
Uh-oh.
Team?
I swear I am here live and Stephanie is sitting right next to me.
No.
I hear you. We hear you.
What's happening?
We hear you.
Okay, well, this is great. Go ahead and intro us as I continue. I'll just provide voice in the background.
I know we're doing the English show today, so we'll start with that. And happy to have everyone here. First and foremost, listen, we have a little bit of good news. I like to start off with some good news.
I'm not very happy.
Whoa, I see you.
Yeah, I'm still frozen. Wow. Sorry guys, bear with us for a second as we this is the problem with doing shows live, right? And I got frozen with a very upset face.
Oof, that's all right. I mean, just hit refresh. Close there, get back in, and also close the app Ozbot.
All right.
Guys, you might not know this. We'll start with this news. My resume is actually very extensive. I am also director, producer, junior and senior tech. And I bet you it's going to work now. I know it's going to work.
All right.
I know. There we go. She's come back in. Just change the settings in the bottom. So, friends, what happened?
I don't know.
Oh, hit connect.
I don't know.
Oh, man. She needs my help. You know what? Go get back.
Yeah. I'll go get back.
So, I'll get started with you guys. Right now, today, Supreme Court came out with a decision. And the United States Supreme Court. And 6-3 ruled birthright citizenship is the law of the land. Essentially, what does this mean in effect? No change. Earlier in the year, there was a presidential proclamation in hopes of changing the rules of what constitutes birthright citizenship. And that, of course, is just mute at this point. The highest court in the land has ruled. So effectively, there is no change. Everything's the same. Anyone who had a pending N-400 for citizenship, not an issue. If you intend on applying, the rules have not changed. If you're already a citizen, the rules haven't changed. There have always been a few exceptions, like children of diplomats and so forth, but that's due to congressional law. Nothing that the president can do to change that. And right now, that's how the Supreme Court has ruled. So that is some good news. I know there have been a few other, we discussed them. I'm talking to Stephanie. She's right next to me.
Mm-hmm.
There were a few decisions that came out last week. We kind of talked about that on the show last week, I think in English as well. So listen, at this point, sometimes no news is good news. And you know what? This is what we're going to do here. I'm going to get Stephanie back in. So, you know what you're going to do, Stephanie? You're going to turn on that camera right there. I got a backup camera for you.
I'm going to go turn it on.
Yeah, turn it on if you don't mind. And you know what? We're going to get Stephanie back here. You know, I could do this alone, but I don't like to be alone. And more than that, I like to include Stephanie. You got to hold the button, count to 3, and then let it go. Look at that. I got my production team here. There we go. Miss Matza. There we go. She didn't expect to have to do this today.
I was not expecting to become production today.
You know, you're going to be a part of this production today, one way or another. But in the meantime, I'm going to set that up for you.
All righty. I'll just, be your eyes and ears and your voice right now. So birthright citizenship, it's an excellent decision. That comes against a slew of other Supreme Court decisions that I believe we talked about last week, but I think it's worth mentioning again. Supreme Court issued 4 massive immigration decisions in this session, right? So Supreme Court basically issues its decisions in sessions, and some of the other ones that are relevant. Number 1 is that they ultimately determined that TPS is a choice of the executive branch. So basically, the president has the right to both make TPS and take away TPS. So that is why it was not, I want you guys to understand, it was not a decision on whether or not Haitians deserve TPS, right? That was not the question before the court. The question was, does the president have the power? Personally, I do think that was correctly decided. And so that decision is in fact the case wherein the president does have the ability to ultimately make that decision, right? So that was decision number one with the Supreme Court with immigration. Decision number two is the one that we're actually really concerned with, which they essentially stated that individuals who have green cards they're going to be subject to a far lower standard than they should be. I think that was incredibly poorly decided. And basically what it's saying is, if you were a green card holder and you entered the United States, for instance, and you had been convicted of a crime, then that is enough for them to, at entry, go ahead and put you immediately into immigration proceedings, right? Now, in another situation, what ultimately ends up happening is, right now, clear and convincing evidence is no longer needed. Before, you needed that, and at the very least, right? You needed multiple things, but clear and convincing evidence is no longer needed. So what that means is, if at the border they suspect you of a crime, as in not a conviction, only a suspicion, then they can go ahead and, instead of admitting you as a green card holder, they can parole you as a green card holder. And when you are paroled, essentially means they're putting you straight into immigration court and proceedings. Let's see, honestly, the repercussions of that. That one's going to be very, very questionable. I don't think the Supreme Court made the right decision there, but that is now officially the law of the land. And the only way that would change is through Congress, which we kind of know Congress can't get anything done. So let's see.
Talking about getting things done.
Am I back?
Talking about getting things done.
Was that massive Zoom? Was everyone watching that? Because that was so weird.
That was good. You look amazing.
It was weird. I'm not going to lie to you.
You're like
I
10 out of
felt
10
zoomed
today.
in.
Wow.
I was like, oh my God.
Guys, I think we did great.
You did it. I didn't do anything. All righty. So that is the news that we have. Supreme Court. It's always very fun. Alexis and I are very nerdy attorneys, so we very much love all the Supreme Court decisions and when that sort of stuff comes out. So it's very interesting. Birthright being really the positive there, right? Let's see. Is there anything else we want to talk about before we delve into questions?
I think news-wise, everything's good, right? I don't think there's anything else. The bulletin.
I hope
July's out, so yeah.
That if you were H-1B, you submitted your case yesterday.
Oof. Today was the 12 p.m., right?
Yeah, today was the last.
Is it 12 p.m. today that it was due?
Better not say that.
Was it 12 p.m. today?
Shut up.
Is that a thing? I don't know why that's
Why
on my
are you
mind.
saying 12 p.m.? What if FedEx delivered at like 1 p.m.?
I don't know. You might want to Carfax.
Why would you say that?
I don't know why it's in the back of my mind. Something tells me I know I had to be there today. 12 p.m. maybe. I don't know. I don't know why I think there's a cutoff.
Oh my gosh.
Is there a time cutoff?
We're going to discuss this off air is what we're going to do.
The nerdy attorneys. I think that is a handle we need to exploit. I love it.
Yeah, ultimately. Okay, so we're going to go ahead and go into questions. And as you guys are all fully aware, if you have any other questions, go ahead and go ahead and write them in on Spotify, on YouTube, on Instagram, on LinkedIn, on everywhere we are. Go ahead and write in your questions and we'll answer your questions live.
On Spotify?
Listen, you threw me off. I'm not going to lie to you. You threw me off and I'm back now. All right. Alrighty, so I'm going to go with the first one because Boris, I am familiar with. Having an O1 denied, can I still continue to travel with my tourist visa? And how long should I wait to travel after that denial? So the O1 is not going to affect an existing tourist visa. You can continue to travel with your tourist visa. It's perfectly fine. We obviously have to wait for the decision in order to see what was the reasons for the decision. That's going to guide us a little more as to how to proceed, whether it be with appeals, for instance, or refiles. There are multiple steps that you can take after a non-immigrant visa denial. However, in the case of the O1 specifically, and many other non-immigrant visas, especially if you are abroad, it does not affect your tourist visa.
Oh, yeah. Let me see what else we got here. I guess I'll go with Lau Chavez, 1995. Hey, O1B ends in October, but have to go back to Argentina to extend it through the consulate. Well, why? Is it new employment or extension of the same with the same employer or sponsor and memo? It's just the same extension needed, but just extension of status. And overall question, should I treat it as an extension even though I'm leaving and don't require status extension? Same terms of employment. So, Laura, if you need to travel outside the United States, automatically it's consular. An extension of status would be if you are remaining in the United States. So, but that it's new. It's new, and you would mark same employer though. That's not an issue. But definitely, if you're traveling, and something that you might want to consider if you're doing an extension of status is can you be here until the approval? If you travel outside the United States while the extension is pending, you're abandoning the petition. Also, guess what? You do need to show that maintenance of status. So maybe payments to you that are in line with what was presented in the contract. But if gung ho, you're going consular, it is new, same employer, not an extension of status.
All righty.
I hope you're doing that with us.
Let's hope so, right?
Yeah, I think so, right?
And then she also had this overall question. Did you cover this one?
Yeah.
Okay, perfect. All righty. Ricardo Sarmiento, hey, Choppy Champions. Okay. E2, like April 2025. Should I pay for premium processing or keep waiting? Wow, that's a rough one.
E2.
Because E2, you did either a change or an extension within the United States, right? You've been pending at this point well over a year. I think officially they are saying 12 months. Alexa's going to look it up now. Mm-hmm. But my concern is as follows. When April 2027 comes around, I want to be able to show that you've been working in the company. You're not going to have much time to be able to be working. And number two, I want to be able to have an approval before that time comes. So I think I would, because honestly, with an extension, they couldn't have continued working. Mm. Could they have? No, they could not. Is there a loophole on that one?
Yeah, like a 4-month.
I think, hold on.
So here's the thing though. April 2025, I'm just going to put April 1st, right? 2025, just to be as
What's the official
as
thing?
possible.
Processing normally?
December 2026.
That's
meaning you're still within processing times up until, and mind you, this can change in a week. It could change in a month. It could get even, take longer. But they've generally been taking about a year if you don't do premium processing. So yeah, you're looking at it still within processing times. It's what? 18, 20 months at that point, 20 months, December 2027.
Okay. So your automatic work extension has already expired. And I need you to be able to show that you've continued working in the E2 business. Because if let's say that this is approved in December, right? Which is when you can make an inquiry. Then you need to file in April 2027 again. And all you're going to have as proof of work of yourself within the business is 3 to 4 months. I would do premium. And next time I would absolutely do premium. I would never do regular processing with an E2.
Yeah, ease for a while now. It's really recommended to do premium processing just because of the processing time. And you lose out on that advantage. Good luck, Ricardo. Okay, we're going to take a question from Instagram. Pauline Velandia, and I'll translate this. Hi, for an EB2 NIW, question. Once we submit the documents, how much time does it take to receive an approval? Okay, that's great. Current processing times are hitting like 26 months, 24 to 26 months for an EB2 NIW I-140 without premium processing. So yeah, it's considerable. It's definitely a considerable amount of time. I think at that point you always have to weigh in the fact of, is it worth premium processing? Maybe from the beginning, 60 business days, 45 business days. I always think 45.
EB2 is 45.
Right? 45 business days, thank you. And what other status are you on? When is that expiring? If you're not in a rush, go regular processing, probably in your benefit. But if you want a decision soon, they are really taking 24 to 26 months. Just to respond quickly to Pauline in Spanish. Hola, Pauline. Estos casos se están tomando 24 a 26 meses en procesar. Dependiendo cuándo lo introduzco, puede ser que vale la pena hacer un premium processing y dependiendo su estatus legal, pero el proceso regular, como 2 años, 26 meses prácticamente. Yeah, those have really taken a turn.
Yeah. Alrighty, let's go. Mariano Rodriguez, good afternoon. Waiting since July of 2024, my EB2 NIW. Very similar question. Have you seen movements for that priority date? July 2024 is kind of within still this. I mean, at this point, you're going on 23 months, and officially, I think they're reporting 26 months. So it's still, unfortunately, kind of still within the same neighborhood. And it is a matter of waiting. Look, officially they're saying 27 months.
Oh,
so
went up again.
It went up again, right? It's continuously going up. Unfortunately, you're kind of in a position where you can't do an inquiry yet. The first time you could do an inquiry is probably going to be at the end of the year. So you have to keep waiting.
Yeah. That's why sometimes going the non-immigrant route is so important for people, because immigrant visas are taking generally longer. There are a few exceptions, right? Like EB-1A. Guess what? I don't know, maybe 10,000 people apply for that visa a year, right? So the majority of people really need to take planning into consideration, whether it's student visa, E2 investor's visa, employment visa, talent visa, so O's, L's, P's, maybe an R. Obviously H-1B is a very popular one, and L as well. But that strategy is so important. And I mean, every time we field calls, I feel that half of the calls I deal with on a daily basis are creating that strategy. People aren't ready to make a decision yet. They want to be informed, and we got to develop that strategy. I know we talked about CESPA a couple of weeks ago. We did CESPA Spanish last week. I had a call today about CESPA. And so it's truly important, because you want to see how the family's included, when can you work, who can work, at what time. Not every spouse can work depending on the visa. So it's all truly important. So contact us. Shameless plug. IGPO, I got my driver's license in Texas with my TPS extension. I'm assuming that's TPS. 540 days of work permit. Okay, true. Crazy, no? A little bit, especially in Texas.
Insane.
After save verification and O1 pending. That's a good tidbit. I mean, hopefully your O1's approved fairly soon, right? You really want to get off of whatever status you're on, temporary status, even though non-immigrants are temporary. But an O1 is a great option because it's one you can renew. When we talk about sometimes, and this is going on with strategy, maybe H-1B will get you there. Depending what country you're from, you want to do a perm down the road. Maybe you need to transfer over to like an O1 if you already hit the maximum period. So that happens a lot with employees and employers and Ls. So I'm glad you did O1 IGPO. Hopefully it's approved. And thank you for keeping us and our followers informed.
Laine, I know. I saw this actually right before the show. They approved the H-4 visas today. Congratulations. This is actually really important to say here, because for those of you who are Venezuelan or from any other country that was subject to the 39-country pause, which I believe also includes Haiti,
I think so.
and Cuba, those countries, remember what we discussed. While USCIS is appealing the decision, they do not agree with the district court that the 39-country ban was unlawful. They are saying, while we don't agree and we are going to appeal the decision, we are going to start issuing decisions for the 39 countries. And I can confirm, as of last Thursday, we have been continuously, finally receiving decisions for Venezuelan cases. And Laine got their approval of their H-4. So that is really, really nice news. We're very happy. We were actually discussing this morning, which is, if a district court determines that the 39-country pause is unlawful, right? And USCIS basically says, while we don't agree, we're going to go ahead and vacate the policy memos. Does that mean that Department of State will follow suit? So Department of State being consular processing, right? Generally, no. Generally, what USCIS does not affect Department of State. We need to wait for Department of State to also say that they are no longer honoring the presidential proclamation. As of now, they haven't. So basically, this only applies to decisions of I-129s, I-130s, I-140s, but it does not apply to immigrant visa or non-immigrant visa processing via the consulate. Excuse me, only immigrant visa in this case. Yeah. I
mean, still good news that we're getting some traction, especially USCIS. A lot of people from those 39 country lists were on something temporary, let's say like a TPS. So that's good news. Whoops. Yeah, there we go. Something's working here, right?
And just really quick, any news about another approval of Venezuelan EB-29W? So yes, so we are already receiving approvals, thankfully.
Yeah, it's great news, honestly. I lost my, here we go. Sam says, hello, Santo Mota from the Dominican Republic. I'm a programmer with 11 years of experience. You think my profile's for an EB2 and IW? So a lot of things to consider with an EB2 and IW, and I like to divide it to keep it as easy as possible into two realms. One is you. What have you done? That's going to be, let's say, degrees are great. Post-baccalaureate work experience is going to be great. Additional certificates, membership in professional associations. Those are things that help. Your role as a teacher, an author, judging, awards, recognitions. You have that, we might consider a different visa, or guess what? We can use that for an EB2 and AW. It helps to show that you are well positioned to do what? The other realm, the second part of the analysis, but the second part here, the second half, which is what is your proposed endeavor? What substantial merit, what national importance will it have? We're talking about macro and micro. So impact overall, is this something that the country is looking for, the industry, the economy, and directly how's it impacting employment, society, economically speaking. So there are a lot of factors, and some of those are subjective. So it really depends. I understand you're a programmer, 11 years experience, you probably have your bachelor's, everything's looking good on paper, but what's your endeavor? What have you focused on? What are you bringing to the United States that will make some sort of impact? So those are really the questions we have to have. I think you should have a consultation to really pan that out. And maybe if you have some of those extracurriculars, like the judging, the authorship, the teaching, your role as a presenter, speaker, guess what? Maybe we should be thinking of a different visa. But it's definitely very important to have that consultation. I'll say quickly in Spanish, Sam, muy posible que califique, mejor tener nuestro contacto para hablar un poquito más en detalle sobre su currículo en particular, porque eso depende y influye.
Lau had a follow-up.
Oh, yes. I'm not doing extension of status, but I want to know if it's new employment or extension of the same work with
She
the
wants to
same
know which
employer,
boxes to
even though
check.
I'm going through consulate.
She wants to know which boxes to check.
It should be new employment.
It's new employment,
Yeah.
notify the consulate.
Yeah, absolutely.
Even though it's an extension,
I know.
there's a different place in the forms to mark that. So first, page 2, there's like a little box that says provide your previous receipt number. And then page 4, question 8A.
Is it 8?
Yeah. 8A is going to say, have you had this before? And that's where you mark it. So that's how they know that you've had this before, which is going to help with the future petition. But yeah, you have to mark notify the office, new employment.
By the way, include the approval of the previous I-129 as well.
Let's see. How long are O1 pending applications taking? Or premium process working in Venezuela? Okay. O1s are currently taking, I think, 12 to 13 months officially. I am seeing it also at 12 to 13 months. For anyone who is not on a banned country, on the 39 country ban, I recommend premium because that is a crazy amount of time. But if you are if you're subject to the ban, I would not pay premium. While they said that they are honoring the district court's decision, I would be hesitant if I'm Venezuelan to still pay premium until I have something official that says that we are now honoring premium for Venezuelans and we are officially doing that. Because I've had many clients who lost $3,000 because they paid premium and then they did not end up getting the decision within premium time. And it's very sad. And I don't think those people are going to get their money back because USCIS is going to claim national security, right? So I wouldn't do it. I would probably send your case. And then if we see changes, you can upgrade to premium. Whenever your case is pending, you can always upgrade while it is pending.
Absolutely. Gonna take on this one from Cesar Quintero. So he has an interesting question. You know, what are your thoughts on the ban on the 75 countries? Okay, well, it's there. Do you think it will be lifted into 2026? We are soon concerned in Colombia. Adjustment of status has become so expensive. And I get it. You know, with an adjustment of status, you have to plan not only coming over, but do you want that work permit, that temporary work permit while everything's pending? And so you definitely have to plan for that move and that time that you're going to be without the ability to work. I don't think it's going to be banned or lifted anytime soon. Why? There has to be separate litigation. Even the 39 countries, the concert processing there needs to be separate litigation. Once that comes in, maybe, and once there's a decision, maybe it'll change something. Right now, there's no indication. I would hope that by the end of the year, there are a lot of changes in all these countries, by the way, right? The conditions in Venezuela, and I know the earthquake last week is a terrible, terrible news, and our hearts go out to everyone that's there right now. But on paper, it looks like the country's in a new direction, right? At least that's how the federal government's treating it. Probably now the same in Colombia. So why are these countries still banned? Why should they be banned? They should be lifted, right? If the conditions are there. So it's tough sell. I think either Congress has to act or there's going to have to be some sort of litigation. Or guess what? Plan for a non-immigrant visa, come in under an O1, come under an L, an E, especially Colombia. You have all these choices to decide. Now, if you already have an approved I-140, sure, might limit you, let's say like E, the E1, E2 investors visa, but let's consider other options to get you in here. Do the adjustment of status, but that way it's not impactful. At the end of the day, the fee for the I-45, when you add up all the fees of the DS-260, it's almost the same. You got to pay for a DS-260, you got to pay for this, you got to pay when you're coming in. It adds up as well. I think the most important factor is the ability to work. So maybe strategizing and helping will help you out, or consider waiting. I couldn't tell you how long you're going to wait for, unfortunately.
All righty, let's go with the next one. Gladys Portilla, today is a special day. I got my permanent residency card, my green card, thanks to you. And thanks especially to Gil Brito. Gil's going to be here on Thursday, guys. So for those of you who missed Gil, he will be here on Thursday.
No way he's missing that.
You guys are my happy hour. Very sad for what's happening in Venezuela. Venezuela is such a hard situation right now. We have a lot of clients that have been affected. We're currently working and crunching through emergency travel permits, humanitarian visas. It is very, very sad what's going on. It's very sad that they are unable to rely on a government in order to assist them. Our hearts are truly there. We're all very much suffering because we have a large connection here in the office to Venezuelan clients. So
I mean, it's
very
friends,
sad, but we're
family
happy.
as well.
Yeah. Thankfully, no one in the office family, but it's a very rough situation.
It's interesting to see, though, how people are really coming together. Not only Venezuelans, and countries are doing, helping, and donations are coming in. Miami, I mean, we're here, so of course, there's a significant Venezuelan population. The next day, collections going over. So it's nice to see that. I wish we wouldn't even have to see that, of course. And hopefully there'll be something there, some improvement there for the people that are there directly impacted soon. Let's go a little bit here with Socrates. If I married after filing an I-45, EB3 employment, but before the green card arrives, does I-824 apply? So, where's your spouse? Is your spouse in the United States? Can your spouse travel to the United States? If they can, you can have them come in, enter the country, wait 90 days if it's, let's say, a B1, B2, or an F1 visa. And after that, do the adjustment of status here in the United States. If for whatever reason they don't have the ability to travel here, once you are a green card holder, you are going to file that I-824. We're going to send that or USCIS, after approval, will send that previously approved I-140 to the National Visa Center, NVC, and then NVC will reach out to get started on stage 2 for your spouse, the DS-260, which is equivalent to the I-45. So it is fine if you marry after filing the I-45, but before approval. If you're still, thinking about it, sooner rather than later. Hey, congratulations on getting married.
Let's see. Happy Tech. How can tech consultants providing services to major U.S. companies prove critical role when you can't get a letter from the client and most company materials are confidential? Can independent expert letters help? Very difficult. I will admit it's very difficult. First, let's put a caveat here. Anything submitted to immigration is in fact confidential, right? And anything obviously you share with the attorney is in fact confidential. So the only individuals who could request a case copy is via a FOIA, and that would be either the petitioner or the beneficiary, right? So in that sense, I feel like you should feel confident that you're going to go ahead and be able to submit that confidential work product. I have no problem there. Now, if you can't get the letter, perhaps you can get email exchanges. Perhaps you can get a contract. Perhaps you can get proof of payments. Perhaps you can get, what else? Organizational chart is not going to be because it's sort of independent contractor type work. perhaps like thank you letters, or maybe you actually spoke about the consulting services at a different event, such as in a newspaper article or something like that. I doubt it because it's confidential, like you said. But I would say, yeah, I would go with err on the side of email communications, contracts, and proofs of payment.
I mean,
it's very difficult.
Also, did the work itself receive an award, some sort of recognition, right? And then if we can tie you to the work a little bit, that might help up. I know it doesn't really discuss lead or critical, but it might be more along distinguished. But at the same time, if there's talk about that project was critical to that other company's success, then maybe you played a lead and critical role for the company there too, right? So those are always the tough ones, right? When you can't get them. Maybe
proving your connection to the project is the most difficult thing.
Maybe there was another company that worked on it too, and they're willing to write the role. Maybe you withhold what the company is, and then in a separate letter or document, it says what the company is. You can manage it. I've seen it done at the end of the day. But yeah, that's a tricky one, Happy. Going here with... Oh, Socrates had a follow-up question. That's what I was going to do. Sorry. How long does the I-824 usually take to arrive? It's taking about 6 to 12 months to get the approval. If your husband's overseas, it's irrelevant if your husband's abroad or not. How about if I go the military route to naturalize, file 9-130? What do you recommend? I think that's going to probably take longer, honestly.
I agree.
So filing the I-824, once that's in, you file that DS-260. That's probably going to take maybe 6 to 9 months to have that interview. So you're looking at anywhere between a year to year and a half of getting that in. I don't think the military route will get you in there faster and naturalize. And then have to file an I-130. I think you're adding more steps and more than likely more money. It's really up to you. I mean, we've done a few with the military route, but those are usually people that's what they want to do. They're not doing it for any other reason. And I think that's something that you really need to consider before making that decision, Socrates.
Absolutely. All right, let's see.
Got a lot of questions today.
Juan, EB-29W I-140 pending approval. I will be traveling to the United States in December. Will they question me or deny me entry? I'm going with my family to spend Christmas in the United States. Very unlikely that they're going to give you any sort of issue at the border, if they were even to ask you. I want your response to essentially be, look, I'm visiting for Christmas. Here's proof that we're going to, I don't know, this fireworks show for New Year's. Anything that you have, any reservations at restaurants, anything you could show that this is in fact really tourism. And then I want you to be completely honest. Yeah, we have an EB-29W filed, but as the document says, we plan to return to do consular processing. This trip is only for tourism for Christmas. And honestly, you shouldn't have an issue.
Absolutely. Can't wait to spend Christmas in Miami. Wonder where you're going. Here we go. Carlos Marino. My employer filed an I-129 for TN extension with premium processing. I'm from Venezuela. I've been waiting since May 12th. Did you see any movement with the pause? So we're not surprised, but there was movement, like Stephanie brought up earlier. Last week, we started to see some of those decisions coming in. I wouldn't be surprised if yours is coming in soon. If you want, reach out. I'd say USCIS Premium Processing Unit and kind of friendly reminder of, hey, this has been pending to premium processing. What's the status? But reach out directly to them. I wouldn't even do a service request. Reach out directly to them and see if maybe you get some feedback and hopefully an approval. It's just an extension, so it should be easy peasy.
Let's go with Pablo Hurtado. EB3 skilled worker, recently approved labor certification. If they deny my B1, B2, would it negatively affect the approval of the EB3 consular? No, unless they're denying it because of some sort of criminal history, okay? But if it's only denied because of, for instance, immigrant intent or anything really not significant, then it's not going to affect the perm. And especially, let's say they deny you on immigrant intent, that especially won't affect the EB3 because the EB3 is an immigrant visa, right? You're saying that you want to permanently be in the United States. Por poner que no tengo petición de inmigración, que no hay que... Okay. Yes, you can indicate that you do not have an immigrant visa petition filed if you have not yet filed I-140. That is completely accurate. You only have to say that you have filed an immigrant visa once the I-140 is filed, not the perm.
Technicalities.
Mhm.
I love it. Okay, Benito Perez. Alexa, you're a great English teacher. Perfect pace for us as ESL listeners. I am not an English teacher. I am not going to take
He
on
does
that
have good
role.
pace, though.
But thank you very much. I completely understand. Thanks for watching, Benito. And follow us on Spanish. Well, I don't know. ESL. I'm assuming that's English's second language, but you could
English
be
is
from
second
anywhere.
language.
I don't know.
Look at me now. I used to be ESOL. I really was.
Great.
Look at me now, just blah, 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 breezing through the English language.
I love that.
Belu. So for O1 and O1 extension, it's taking more than a year. It used to be 3 to 6 months. Yeah. O1 is currently at 12 to 13 months, and it is like on the nose. That's the official rate, and that's the actual rate. So for O1, I'm really, really recommending premium for the grand majority of people.
You know what, though?
Or get your extension started a year in advance. Remember, you can file up to a year in advance.
A year advance, exactly. I remember a long time ago, hey, it used to take like 8, 9, 10, 12, maybe even 18 months. And premium processing was like the law of the land. And then all of a sudden it was 3 to 6 months. You're like,
beautiful.
This is great. You don't need premium processing. Well, guess what? Now you do.
Well, speaking of, actually, so another one that was the law of the land, perm, I-140 for perm, based on a perm, that one, law of the land premium. I did not even let my clients consider not premium. I was like, you are forced. You must do premium because the wait was just too long and there were too many variables. What if something happened with the company? Way too many variables. Today, EB2, EB3 perm, 3 months.
Yeah, it's amazing.
3 months, which is amazing. So actually you could save yourself $3,000 if you're doing perm and you don't have to do premium on that I-140.
Yeah. And strategically speaking, it's almost beneficial because your priority dates for most of the people are at the cusp.
Yeah.
And so by the time the I-140 is approved, 3, 4 months, let's say 6 months max, guess what? Your priority date just hit or is about to hit.
Correct.
So you might as well put the money to that.
Correct.
Let's go. Listen, guys, we like to win cases. We like to secure your status and we like to save you money. Hi, Alejandra. I'm Alejandra, a legal permanent resident. Through the EB2 and IW, I moved to the U.S. in August 2023. I'm married with a Canadian in January 2025. We had biometrics March 2026 and no movement in the case. I'm not surprised. Those cases are hit or miss. Sometimes usually it's United States citizen, marriage-based, LPR, interview, everything set within 3 months, 4 months, 5 months. Legal permanent resident, guess what? Those are taking longer. It could be a year. It could be 2. Those are the official times.
Yo le pongo más.
Yeah, it could be even 3.
USC is taking 3 months. LPR is taking over 24 months.
Forever.
For sure.
So, have patience. Be on top of your work permit. Renew it if you need to. You might just be getting the work permit if you haven't gotten it yet. I guess biometrics are in March. So, unfortunately, that's the official times, Alejandra.
She has a follow-up.
And the other question, if I request an expedite because of this medical condition for travel to Canada for medicine or have the same social number of years, is it a bad idea since the OS situation is kind of uncertain? I mean, you can travel anywhere you want. If you're talking about the foreign national, right? So as a legal permanent resident, you may travel in and out while the petition's pending. Now, your spouse, if they're here in the United States.
His medical condition.
Oh, for his medical condition?
So he would need an emergency travel permit.
So if he requests an expedite because of his medical condition, right? Since he's the Canadian national, you can try if you really need to travel for that. Mind you, if you have a pending I-131 application for permit advanced parole, that will be canceled out. They're gonna close that case as if it never were. You lose your money. You can apply for the emergency. You go in, you do info pass, you go to the local field office, and that field office will evaluate the criteria. They'll charge you separate fees for the I-131. You're going to submit a new I-131, and based on your conversation there with the officer and the evidence that you provide, they can issue you a one-time travel permit for an emergency use. So it depends. Is it something that you really need? All right. If it's not, you have to weigh in. That's definitely a big consideration for people. economic barrier, it's not on the individual. It would have to be for a U.S. company, by the way. So I know that comes up a lot.
For him to travel to Canada.
Yeah, it's for him.
You need an emergency travel permit. And then, like Alexis said, they will cancel out the existing I-131, and they will likely only give you the emergency travel permit for one entry.
You have to use it within like 30 days or 60 days.
Something like that. It depends on the officer, I think.
Yeah, there's some flexibility there, discretion, I should say.
Socrates is another follow-up.
Socrates, thank you, Alexis, regarding I-24. He is from France. Could he get into the U.S. with ESTA and do a change of status, or have to do an F1 or other visa once my green card arrives? What would you have him do?
Sounds like you need a consultation, my friend.
Yeah, I mean, listen, you have a lot of options. I think you need to weigh it in, but technically with ESTA, you cannot do a change or adjustment of status, neither one. So you would need to come in already with a B1, B2 tourist visa, an F1, or any other visa thereafter. Have the consultation. We'll help us get everything squared away. Jasper.
Interesting question. If someone feels stuck in their local market and knows they have real talent, how can they tell whether they may actually qualify for a serious immigration path instead of settling for less? Honestly, look, I would send your CV or your resume to us, and we will be very realistic. So I think people get very surprised when they speak to us by phone or by video call, because I don't know, 8 to 10 consultations in a day. And I only offer cases to about 5 to 6 of those. To the other 3 to 4, I tell them, hey, listen, you're not ready yet, but this is what you need to do in order to get ready. So we can provide you a realistic idea of whether or not you can qualify. I know there are a lot of attorneys out there that, and this sounds awful, but they're a little desperate for the business, so they'll just take anything that comes their way. We're very blessed in that we're not in that position. That's why we like to, give back to the community, answer your questions live regarding immigration, because we're blessed in that ability to do so. And part of that sort of blessing is that we can go ahead and have a conversation with individuals and say, look, I don't want you to spend that money just yet because you're not ready, but you can be ready by doing these couple of things. And that is all the time. And I promise you, it's with me, it's with Alexis, it's with Andrea, it's with Gil. All of us are going to be the ones who are tell you, hey, not yet, or hey, if you really want to go, it's a 50-50, or yes, you're fully ready up to now. If you feel stuck in your local market, absolutely immigration can be an option. And what we're going to go ahead and do is guide you in the sense and say, hey, listen, in order to be able to make that route, this is the way to do it. And it's also the consideration of temporary versus permanent. So I know a lot of individuals who feel stuck in their local market, but they're not sure if the USA will go much better for them. So there are a lot of individuals who start with temporary non-immigrant visas, sort of test the water, see how it goes. And from there, they make the jump to permanent residency. So there's a lot of options we could explore, but I would definitely suggest having a consultation so we could sort of give you the idea as to, okay, what's the best and worst case scenario if I go ahead and decide to do this immigration path.
Yeah, I agree.
Yeah,
I agree. It's that there's so many people that are really skilled and great at what they do. I mean, beyond expert, right? Or borderline hitting that expert. And what you have to understand is the standard isn't what's considered so much, 50-50. The standard isn't as much what's considered expert in the field. It's under the rules of immigration. Are you an expert? Yes, we're going to compare you to others within the field, right? So that part is true. But the criteria and what that means is all defined. And through the law, through the rules, through the policy memo, through manuals, to help guide the officer to make that determination. So what you might say is, well, you know what? I haven't reached that level. I am not the creme de la creme. I'm not the Albert Einstein. Guess what? There are only a handful of Albert Einsteins. There's only one every decade, right? Or every lifetime, whatever it may be, right? But guess what? When Albert Einstein was alive, there were other people that were just equally as skilled and as intelligent and in agreement or disagreement with different theories, right? So what it means to be an expert, we're not saying the best. We're saying you're there in the realm of the best, right? And how we define that. So sometimes you say no to opportunities because guess what? You're not interested in it. But for immigration purposes, it might be good. So change of heart. Now you're interested in that. Always worth having that consultation. Jasper, always following us. Thank you. I like this question a lot. Happy Tech asks, and how do we feel about I'm going to let you pronounce that
The
one.
Mukherjee.
There we go. Case decision mean for EB1 final merits. Now it's relaxed or not being considered as heavily.
Really nice.
So it's good overall. It's not 100%. There's no more final merits determination. I want to start with that. I want to preface with that.
Yep.
We are still to argue final merits determination. We're still to push the review of all the evidence on file of the good, the bad, and the ugly. What do I mean? If you receive a request for evidence and the officer gave you one category or 5, you obviously respond to that and make sure you're getting at least 3 out of the X number of categories that you argued for your petition, 10 being the max, right? Now, the final merits determination, I think what needs to be crystal clear is the officer needs to analyze all of the evidence. You're going to push that, and that's always been the case. But what you can now argue is that there's case law out there, right? It's a district court, right? So it's not binding, but it sure does, what is it? Suggestive, persuasive precedent that, hey, USCIS officer, this really doesn't hold as much weight. And so I agree that relaxed, maybe considered as heavily. Yeah, I think that part's true. I think that's part true. I mean, and we'll see how the results come in. We're responding to RFEs now with this.
And I currently have an appeal pending. So I'm really excited about it. I did it on purpose. I want to see what the AAO says to me. If the AAO says, you're right, Mukherjee applies, final merits is not in play, then that's going to be really beautiful to apply to other cases. Because as Alexis said, it's kind of a problem because it's very specific to the Nebraska district, right? And it's not technically applicable overall. So we have currently an AAO decision pending, and we're trying to see what they're going to say.
Yeah, we'll know in a few months' time, and there's other clients.
I'm really fighting it. I'm really fighting it.
I'm glad that you're getting that done, because I have a client it just happened to last week, and this decision was released. It's going to be 2 weeks now, right?
Mukherjee?
Yeah, 2, 3 weeks.
Well, Mukherjee's 2 months.
January already? May, sorry.
In 2 weeks.
May? I don't know. Everything, there's always some news. So, and I said, you know what? This is here. Why don't you consider this? And so the person might appeal. Mind you, I'm sure we refile and we win this case because it's such a wonderful case.
Let's go with Melly. Is there anything to do in an option while we wait for the 801B? Because waiting 12 to 13 months is not being able to work is impossible. I completely agree with you. So obviously you're in a situation where we don't recommend premium because you are from Venezuela. It's very likely that you would lose the money. So what are the options moving forward? Number one is truly hands tied, continue waiting, not working. And then my bigger concern there is when it finally is approved, I don't want you to go immediately to the US consulate to stamp, because what happens? They're going to be like, so what have you been doing for the 12, 13 months? And they're going to give you an issue. So the second that is approved, I need you to start working, have at least 2 to 3 pay stubs under your belt before you go get that visa issued, if you want to get the visa issued. I've also had the situations of clients who said, you know what? And they were specifically Venezuelan. And they said, I'm not waiting anymore. This is ridiculous. I can't be so long without working, which I completely agree with. It's fully fair. And those individuals decided to leave the United States and wait the process abroad. So what ended up happening is basically they haven't gotten this decision, but what they will do, because I've done it over in the years past, is they will say, okay, we're denying the extension or the change of status, but we're approving this for consular processing because we see you have departed the country. So you can basically leave, continue working in your home country, live your life. And when it is finally approved, you would go to the US Embassy, get the visa stamped, and then come to the United States.
Absolutely.
So.
That's such wonderful advice. Not every attorney will tell you that. It takes an all-star attorney to tell you that.
Wow. Why are you buttering me up so much? What's going on here?
Hey, does the truth hurt? How does the truth feel? Thank you, Alejandra, for following us and asking us such great questions and wonderful questions. How do we contact premium processing?
I don't even want to tell you. Don't tell them. Why would you put that on the screen?
How? Listen, contact us and we'll contact them for you.
Okay, here's the situation.
No, yeah.
Here's the situation. You're gonna be, you say this nicer than I am. Go ahead.
Listen, it's just there. You got to look at the receipt notice.
Don't harass premium because you're gonna ruin it for the rest of us.
Yeah.
If they start getting a ton of emails from people, they're going to be like, you know what? Email's over.
Oh, okay.
It's 100%
Look,
accurate.
they'll change the email address.
Will.
It's happened.
I'm telling you, it's happened.
They
I
used
know
to
I sound
have-
insane, but I promise I've been doing this long
They
enough
used to have a
know.
phone number.
Yes.
Call that number today. No one's going to answer.
No one answers anymore.
It reroutes you to
don't
the regular number.
ruin it for the rest of us.
So-
On the, yeah, you're right. On the receipt. On the receipt, it has the email address. Bother them very exclusively.
You get one time.
Once.
I'm telling you right now, you bother them, they will deny your case.
That's exactly where I wanted to
That's all
go
I'm
with
saying.
this. Yes. Be
They're not going to deny the case because you
extremely
bothered them. I'm going to tell you that. They're just going to deny your case.
Be extremely
They'll find a reason.
nice.
Come on.
And then when you have the beginning, you're going to put the receipt number, petitioner name, beneficiary name, date of birth, country of issuance, date of, you're going to give them all that beautiful information. You're going to be like, hello, officer, you sweet, sweet thing. I love you so much. Hey, listen, can I get one little quick update? Like
Can I tell you,
that.
guys, this is a professional process that you're going through with the United States government. Treat it with all the formalities of the world.
Very formal.
Okay. It's interesting because there are a lot of people that treat it extremely formal. I'm talking about suit and tie to an interview. And there's other people that are writing in all caps. And maybe you're not sure what to
In
do.
all caps is crazy.
Or not how to communicate. Guess what? They're not your friend. This is a professional setting. And if you need help just for that, we'll do it. We'll figure it out. We'll do it for you. I always tell people, this is important, right? This is like cheating on an exam in the university, right? That's a big thing. Well, guess what? How you communicate with a government entity is a big thing, especially when it comes to a decision like this. They'll never tell you they denied you for that. And I truly doubt that they would. There are wonderful people at USCIS. But guess what? They'll look for a reason. Come on.
It's not very nice, but it's true. It's 100% true. 100% true. Once he took that, I was like, oh no.
Oh no.
What's the timing that you guys have seen to get work and travel permits in a case like mine, LPR? This was LPR marriage based.
Mm-hmm.
Okay, LPR marriage based work permit is currently taking, I'm going to say like 5 to 6 months for LPRs, LPR spouse. And then travel authorization is taking closer to 8 to 9 months. So if it is for the medical treatment, you would need to request that emergency one. If you already requested it, then check the processing times. And if you haven't gotten it, do a service request.
By the way, you can also contact them. So wherever that pending I-131 is, and you can request that they expedite it. So you can take that first step if you'd like. And there's a way to expedite it. They give you like 6 reasons why, and you pick one and you write to them, and maybe it gets done. And you get the multiple entry. Maybe for medical treatment, there are future treatments that you have to consider, right? Maybe it's treatment a month for the next 12 months, whatever it may be. And therefore, one emergency permit won't really do what you need. So maybe that's the route you want to take as well. So maybe expediting what you currently have might be the route you want to take.
I have a question for you that I just thought of. I'm hesitant to tell USCIS about the medical condition. Could it affect public charge evaluation? Like, you know, I'm thinking
saying.
very much outside the box. This could be a non-issue, but like, obviously we're getting paid to be able to think outside the box, right? So I don't want the officer to think that you have or the spouse has such a medical incapacity or medical condition that they may in fact have to rely on the US medical system and prove to be a public charge. So I would be very cautious in how you present the medical treatment. I don't want you to say things like, this is continuous for the rest of his life. This is something that he's been suffering with forever. This is something that he's going to be reliant upon forever. I want it almost to make it seem like it is temporary or might diminish it, right? Diminuirlo. So diminish it and basically be like, look, this is normal. This is part of his life, but he needs to go obtain his medication, and he obtains his medication typically through Canada, and that's why he needs to travel.
Like a regular treatment.
Right. So just be cautious in the way I don't want you to, because this is why I'm thinking, right?
Yeah.
Maybe she wants the emergency travel permit to be approved so badly, she exaggerates it.
Of course. Yeah.
And then that works against you.
I agree.
That's what I want to call it. Don't exaggerate it in hopes that you'll speed up the emergency travel permit or the regular travel permit.
Mhm.
Don't exaggerate it because exaggerating may work against you. That's all I want to say.
I agree. And the thing is that public chart, nothing's official right now. It's,
Right.
it's more of a feely, subjective process right now. So we'll see how it's truly implemented. And that's really through a Q&A at the time of the interview. I agree with Stephanie. And I will say, don't make it as a reliance of, hey, I have medical coverage there. And listen, I seek treatment. This is treatment that I regularly get.
Mhm.
Or maybe there's maybe it's a single thing, one-time thing or part of a 6-month thing, something temporary, but the doctor's there. That's where your specialist is. Don't talk about money. Don't talk about anything like that. Because also at the end of the day, if it is a lifetime thing, I don't want to scare anyone either, but hey, if you need that medical treatment, go get it. It's a lifetime thing. Guess what? Other things that they're going to consider is, well, do you have the funding for it? In a future interview, what's your economic situation like? Is this person, are there positive factors to consider, right? Are you involved in the community, involved with your religious institution, nonprofit, whatever it may be? And, those are all positive that outweigh the negative. But you're saying, oh, I'm going there because of free healthcare. Forget about that. That's where your specialist is. Let's focus on the medical part of it and not the financial part either.
Yeah, just don't over exaggerate it, right? Just be like, hey, listen, look, no, this is a continuous medical treatment. I need to go to Canada to get it, right? Not like, oh my God, I will die if I don't have this. This is the worst thing ever. And it costs millions of dollars in the United States. And that's why I need to go to Canada. No.
Leave that
part out.
Yeah. I really like this question here. Hi, Tropies. We submitted an EB1A with premium process with you. We are
like
the 13th
this question.
day
You like this question because you want to be like,
with no response yet. Is that a bad thing? No.
Mia, you have 15
business days. So if day 15, well, no, I guess no, they're working on Friday, so you're fine. But
they're not.
Are they? They're closed on Friday?
Vamos a chequear.
It makes sense.
Vamos a chequear.
I know the banks are open. The banks are open.
Are they?
Yeah, I think the banks are open. It's 15 business days. So if there's a Saturday or a Sunday or a holiday, they're observing it?
Friday.
Okay, so they'll observe it. If they're observing that day and that's part of the 15 business days, then it doesn't count and you push to Monday. So I would tell you, if you're saying today's the 13th day and not business day, you probably you're only halfway there, basically.
I can't believe that banks are not honoring it. That's crazy.
Gotta work.
Gotta work.
Yeah.
It is 4th of July. You know what? On that note, happy 4th of July this weekend, everybody. God bless America. We shall be barbecuing. We shall be barbecuing. We shall be out by the pool, out by the beach, enjoying the beautiful weather. For those of you,
if the weather permits, yeah.
Cállate. Yes, it's going to permit it. So happy 4th of July to all of you. We will not be here on Friday, but we will be here on Thursday for the Spanish show, 12 noon. You're going to have Alexis and Gil. It's going to be an all-boy party. And we will see you guys next time.
Thank you, everybody. We'll see you next week. Happy 4th of July if you're celebrating. Happy Tuesday.
Happy 4th of July.
Hello, Cruz. You guys are the best viewers. Thank you so much. Click, like, subscribe, and share.